Banning AI isn't realistic, but letting it run wild is a malpractice risk waiting to happen. In a legal practice, one mistake doesn't just cause embarrassment, it can sink the entire firm. That's why today I'm giving you a 13-step procedure designed for firms up to 20 lawyers, so you get the efficiency of AI without risking privilege, candor, or client trust. I'm Rok, founder of MPL Legal Tech Advisors. My background is in building compliant AI systems in heavily regulated industries. Recently, we helped a 12-lawyer firm set up their governance from scratch. What I'm about to share are the exact steps we used. Most firms are stuck between two bad options with AI. Either banning AI outright or letting associates use ChatGPT without any supervision. One wastes time, the other invites malpractice. The answer isn't a 50-page policy, it's a lightweight but defensible framework. Here's how to do it. Section 1. Appoint an AI point person. Pick one senior attorney to be the AI lead. They don't need a new title, just a responsibility to keep the AI use safe and sensible. Add two helpers. One is a technically minded person, they would handle the security basics, the vendor checks, and the other is the compliance-minded person, and they would raise confidentiality or ethic concerns. They meet once a month for 30 minutes. No bureaucracy, just noting decisions in a shared spreadsheet. A quick win is do this today. Appoint an AI lead and open a blank spreadsheet. That single move reduces risk more than a policy draft. Step number 2 is clarify the roles and the accountability. Who approves tools, who checks vendors, who signs off high-risk uses. One person may as well wear many hats here. Just write it down so it's clear. The quick win? Send a 2-line email this week. For AI tools, person X approves, person Y checks vendors, and person Z signs off high-risk uses. That instantly removes 80% of confusion. Step 3 is your one-page AI policy. It should have at least 3 clear rules. Never paste client-identifiable information into public AI tools, or any public tools for that matter. Every AI draft must be reviewed and signed off by a lawyer, and only use the tools from the firm's approved tools list. Review it twice a year or sooner if the bar rules change. A quick win? Draft this on a single piece of paper today. That single sheet is worth more than a 40-page policy that nobody touches. Step number 4 is inventory and classifying the tasks. Grab a whiteboard or a shared document. List every place where you think AI might help. Research, first drafts, deposition summaries, marketing. Mark each of them with a traffic light. Red is banned. That's anything involving client data and public tools. Yellow is restricted. AI can draft memos, but the lawyer must review. Green is safe. Low-risk tasks such as marketing copy or email rewrites. We already broke this system down step by step in a separate video. I'm linking it down below. So that's it. No committees or endless approvals. Just agree once as a team, write it down and keep it visible. Quick win? Take 5 minutes this week to mark 3 tasks red, yellow, green. This instantly clears up the "can I use AI for this?" debate. Step 5 is maintain your approved uses. Once a yellow task is tested and approved, move it onto a simple approved uses list. Write down the task, the tool, and the date when it was cleared. Store this list in your shared drive so everybody pulls from the same source. This stops people from freelancing with the tools or inventing their own workflows. Quick win? By Friday, put your first 3 green-lit uses on a one-page list. That's your firm's AI playbook, without any confusion or surprises. Step number 6 is vendor checks. Before you sign for any AI service, ask at least those 3 questions. Do you have ISO 27001 or do you only rely on SOC 2? If they don't even have SOC 2, that's a red flag. Move on. Data use. Will you ever use our data for training? You want a contractual no. If they hesitate, don't trust them. Workflow fit. Does it integrate with our daily tools? Word, Outlook, the case management system? If it doesn't, adoption will most likely fail. There are exceptions, but usually the team doesn't use it. Quick win. Run a 15-minute vendor check call with your AI lead before buying anything. One bad vendor choice can expose your client data and sink the whole AI program, if not worse. Step number 7 is set the basic technical safeguards. Stick to enterprise-grade or on-premise tools. You'd be surprised how affordable these are these days. If you can, run your AI traffic through a light proxy shield, something that automatically strips the names and any kind of sensitive and risky data in your prompts before it reaches the target, in this case, the AI model. If that's too heavy, keep it simple. Anonymize sensitive details before pasting your text, enable multi-factor authentication, use strong passwords, and install updates. Quick win. Ask your IT contact to switch off the data retention in any AI tool settings. This single but powerful toggle prevents most accidental data leaks. Step number 8 is protect your client data. Run a pre-use checklist every time. Anonymize the client details, check the tool's privacy settings, and confirm client consent if required. I'm repeating this, but again, never paste client data into any public AI tools, or any public tools for that matter. Stick to anonymized or internal tools only and enterprise-level subscriptions. Keep in mind, the US Cloud Act means that data hosted on any US servers outside of US can still be accessed by US authorities, even if the servers are physically outside of US. I want to make it explicitly clear, even if the servers are outside of US. Quick win, ban client names and case numbers in AI tools. This single rule removes your biggest exposure overnight. Step number 9, verify every output. Treat all AI outputs as unverified drafts. Never assume accuracy. For legal work, verify citations in Westlaw, Lexis, Decisive. Check authority, relevance, terminology. Keep a short verification log. It should contain a date, a reviewer, and what was checked. Keep it in the matter file. If AI-assisted content finds its way to a client, add a note, reviewed and approved by a lawyer, and a signature. This protects privilege, candor, and your reputation. Quick win, a one-line log entry, enough to show insurers and regulators you care. Step number 10 is ethics, bias, and fairness. Train your team to spot bias or stereotyping in AI's outputs, because AI can easily mirror social prejudice. It was trained on human data. Any recommendation that affects clients' rights, liberty, or status must have partner sign-off before use. Run spot checks. Sample a few AI outputs every month for bias or skew review. If a pattern emerges, pause the tool until you look into it deeper. Quick win. Add a line to the policy. AI may not be the final word in decisions that impacts people's rights. That single clause blocks one of the big potential exposures. Step number 11, standardize your workflows. For each approved AI task, write a simple 3 to 4 step checklist. Example, for a legal research, draft a prompt, step number 1. Save the prompt and the output in the log, that's step number 2. Verify the citations in Westlaw or Lexis, that's step number 3. And the last step, record who verified it. Same logic applies to drafting and contract review. Sanitize, then generate a draft, and in the end, lawyer edits and verifies it. Keep your workflows short and simple, so they're clear and people can actually follow them. Quick win. Start with one workflow this week. Let's say research or drafting. Add the rest as you go one by one, and don't wait for that perfect moment where you're going to be able to pause and take care of this, because that's never going to come. Step number 12. Keep your logs and audit trail. Maintain a central AI use log that captures who used the tool, when, which tool, and a short description of a purpose. Tie matter-specific verification logs into this central register, so both case level and firm-wide oversights are covered. Review the central log at least quarterly to spot anomalies, missing verifications, unusual usage spikes, or high-risk prompts. Retain logs in a secure, tamper-resistant format, preferably linked to your DMS or case management system. Quick win. Start with a shared spreadsheet. As usage grows, switch to automated capture through your AI platform or a proxy shield. And step number 13, train, monitor, and incident protocol. About training, everybody gets 1 hour of training when they onboard. You train them on your firm's AI rules. What's banned, what's allowed, what's advised, and how to review it. Do this at the onboarding plus once a year. And plan a deeper dive for partners and or leads. About tracking, Each quarter, note how many matters used AI, what errors popped up, and where it saved time. A 2-column spreadsheet is enough. About the incident procedure, use a 4-step playbook. Contain, which means stop using the tool. Notify, tell the AI lead or partner and contact the vendor. Document, write a 3-line note of what happened. And 4, remediate, fix and move on. It's not the end of the world. These things happen. Now a local law reminder, American Bar Association, SRA, GDPR, they all require documented training and incident protocols. Quick win. Schedule a 1-hour AI Basics Lunch and Learn next month. That one step ticks your training, monitoring, and compliance box in one go. Thanks for sticking till the end. So here's our takeaway. Safe AI adoption in a up to 20 lawyer firm isn't about big committees or 40-page policies. It's about proof of governance in plain English. One lead, one policy, clear rules, documented reviews, and a simple playbook for when things go wrong. Do this and you'll have what clients, regulators, and insurers all want to see. That your firm is competent, careful, and ahead of the curve. Skip it and you risk being the next headline. All the 13 steps we covered today, from picking an AI lead to building incident playbooks, are about one thing: giving your firm a defensible, practical framework for AI. But a checklist on a paper isn't enough. It only works if it's implemented across your workflows, and if you'd rather not start with a blank page, this is exactly what we consult law firms with at MPL Legal Tech Advisors. Book a call with me using the link in the description below.